Hi, I'm Florida foreclosure defense lawyer Michael Wasylik. I'm here in Dade City, Florida. I'm outside the historic Pasco County Courthouse in Dade City, Florida. And I wanted to talk today about something that's come up in a couple of my cases recently, and that's the question of whether it makes sense to have a forensic audit done of your foreclosure loan, and if so, when. Now, I have addressed in another video, and if you haven't seen it, please check it out, the question of whether it makes sense to track down who the owner of your loan is versus whether or not the bank that's suing you is the holder. And so there's two different issues here. One is the owner, one is the holder. And in my experience, the vast majority of forensic audits are done in order to determine who the owner of the loan is and don't address the question of who the holder is. Now let me take that step by step here. A forensic audit is usually done in a case where there is some indication that a loan has been put into a securitized trust or a loan pool of some kind. In other words, it was bundled up and sold as part of a group to some other bank, usually in cases where the plaintiff is, for example, U.S. Bank as trustee for the certificate holders of such and such trust. Now, if you have a plaintiff that's like that and they are relying on the question of whether they're the owner versus the holder, then you might have reason to go into the pooling and servicing agreement. You might have reason to track the loans that were deposited in the trust, whether they were done so properly, whether or not they were actually properly conveyed to the trustee, and whether that trustee is the owner. But if the bank is coming to you and relying only on their status as a holder, if they're only saying we have possession of a note endorsed in blank or endorsed to us, and those endorsements appeared at the time the foreclosure was filed, and we had possession at the time the foreclosure was filed, then it may not matter whether or not the bank complied with the PSA, because they have an independent way of proving that they have the right to enforce the loan outside of and separate from the pooling and servicing agreement. And so the forensic audits that I've seen focus solely on the question of going through the trust documents, going through the pooling and servicing agreement, determining who the parties were, whether they complied with the requirements in the pooling and servicing agreement, and whether or not those were done in the right time, in the right way, and if so, what are the consequences? So for example, you may find a forensic audit saying that the loan was not put into the pool at the appropriate time by the so-called closing date. Well, that may matter if the bank is proceeding under their rights as party to the pooling and servicing agreement. But if they're merely going forth as a holder, then it may not matter. Proving that they didn't comply with the PSA doesn't matter unless they're relying on the PSA. So most forensic audits that I've seen focus solely on the question of whether or not the loan was properly put into the pool, was properly put into the trust, governed by the restrictions of the PSA. They don't address whether or not the bank is the holder. They don't address whether or not the bank had possession of the note at the time that the lawsuit was filed. They don't address whether the endorsements were on the note at the time the lawsuit was filed. And for that reason, they are usually irrelevant to any issue that comes up in a foreclosure case. They are usually irrelevant unless in your suit the bank is proceeding as a trustee and claiming that it has rights based solely on the PSA, not claiming it's the holder. If you have that case, then it might make sense to get a forensic analyst, a forensic audit done. If your forensic auditor says that he can determine whether or not a bank was the holder, whether or not the bank had possession of the note, whether or not the note was endorsed at the proper time, if you have a forensic auditor who is able to determine that from some records that are outside the bank's records themselves, or based on documents produced in discovery, then it might make sense to have a forensic audit done. You'll be able to tell that, by the way, because the complaint itself tells you how the bank is proceeding. They will say, we're the owner and holder of the note. Well, if they're proceeding as holder status, if they've attached a note which has an endorsement, they're going to be claiming holder status because that's the simplest, easiest thing for them to do at trial. That's the simplest, easiest thing for them to prove up. They're not going to go through the PSA and try to prove they complied with the PSA because almost always they can't. They can't. If you read through the PSA, if you read through the conveyance section, if you read through the definition sections, there's no way the bank is going to be able to prove in a half-hour, 1 hour, 2 hour foreclosure trial that they met all the requirements of the pooling and servicing agreement. Instead, they are almost always going to rely on holder status. And if they're relying on holder status, that forensic audit not only won't help you, it's probably a distraction from the things that will help you. It may be a waste of your money, waste of your time, And it may put you at odds, for example, with your lawyer, who might know better, who might know that that's not going to help you. So before you run out and get a forensic audit done, before you run out and say, who owns my loan? Before you run out and say, I want to march through these documents, I want to get a professional expert witness to testify that this loan never made it into this pool. First of all, make sure that that matters in your case. And you need to talk to somebody who has experience in exactly what it is the bank is trying to prove in your particular case. So if you have a case where you think you might want to get a forensic audit done, if you have a case where you think the bank is trying to prove up ownership through a pooling and servicing agreement rather than mere holdership, if you have questions about that process, you should give me a call. My number is 352-567-3173. That's 352-567-3173. I'm Florida foreclosure lawyer Michael Wasylik. Thanks for watching.